Good morning, everyone. My name is Isabel Franco. I'm here with my good dear friend, Cynthia Catlett of CRA Associates, Charles Rivers Associates. And we have the honor to have Tom Fox with us and Daniela Lassen. We will introduce them in a few seconds. We just wanted to speak a little bit about this wonderful event, Breakfast with Tom Fox. It happens every quarter, and the next one hopefully will be next year, March 1st. The idea here is that Cynthia and I always have a dear friend, client, partner, and it's almost as if it was Charlie's Angels, the three women will speak with Tom Fox. And for the whole event is in English, but Carlos, our interpreter, is in the room, and you can go into the interpreter room and listen to his interpretation of what the whole program here is. You are more than welcome to ask questions. The questions should go into the Q&A box. Also, if you want to ask them in Portuguese, that's fine too, but please identify yourself, your name and the company you're with or office. We really want to know who you are. Thank you. And so I think that's it. Cynthia, did I forget anything?
Nope, that's great. Thank you, Isabel and Tom. I'm really excited to have Daniela as our guest today. I've been working with her for several years. She has a very impressive background and over 20 years of experience in compliance. She currently leads Tishman Speyer's compliance, ESG, DPO teams here in Brazil. And I'm sure she's going to add a lot of value into the conversation in terms of real issues that she encounters day to day leading this group here. So thank you for joining us, Daniela.
Thank you for the invitation. It's a real pleasure to be here with you.
Daniela, be very welcome.
Thank you.
So the format of our Breakfast with Tom Fox is he always gives us the highlights of what's going on all over the world in terms of FCPA, enforcement, compliance. And today the theme is Lisa Monaco's memo and the impact or the shock to compliance. It's very interesting. I just got back from the States, not just got back, but a couple of weeks ago, and heard so much about, was it the DOJ talking to everyone about the effects of Lisa Monaco. They're great. So of course, Tom needs no introduction, but I was so happy to be there in the States to buy many more of his books. Look, this is the latest, it's the greatest book. Tom Fox is the compliance evangelist. Here's the other book that everyone here in Brazil loves. Oops, sorry. And then he will tell us how to buy it in the States through Amazon or I don't know. And as traditionally we do here, at the very end of this breakfast, we raffle off to, oh no, we're not going to raffle, I'm sorry. We're going to give as a courtesy a white paper that Tom Fox wrote. It's going to be both in Portuguese and English. I will let him talk about it. Tom, without further ado, please.
Well, I hope we could raffle off a book as well as the white paper.
Okay, very good. He's so generous, this man.
So yes, thanks guys. I really look forward to these quarterly breakfasts. There was some major information from the U.S. Department of Justice, and it was so important that I asked Isabel if I could send a white paper down to really further explain and amplify my remarks this morning, which she's graciously had translated into Portuguese. So hopefully it will be a resource for you going forward. It is something called the Monaco Memo. And the Monaco Memo is a memorandum issued by the Deputy Attorney General. That's the number 2 in the U.S. Attorney General's office in the United States. It created something called the Monaco Doctrine. This, in large part, was information the Department of Justice had communicated to us, so most of it was not too surprising, but there were a couple of surprises. This memo impacts everyone on this call, and I literally mean that, everyone on this call. It doesn't matter whether you're like Isabel, outside counsel, whether you are like Cynthia, outside consultant, whether you're like Daniela, in-house or law firm, or if you're an in-house compliance professional, whatever your role is in compliance, this memo impacts you and your organization. So I'd really urge you to take a deep dive into it. Then hopefully the white paper will provide that information to you. And as always, if you have any questions after this webinar, please feel free to reach out to me. I'm at tfox@tfoxlaw.com. Happy to continue this discussion. So here's what the Monaco Memo said. It's about I think a 5 or 6 page memo. And there was a speech where Deputy Attorney General Monaco announced it. And then over the next 2 days, there were 2 other speeches by Department of Justice high officials, sort of amplifying parts of it. And here's what is new, or rather puts in writing what the DOJ has been telling us. Last year in October 2021, Deputy Attorney General Monaco gave a speech where she announced these changes. And now they're formalized in Department of Justice policy. That's the Monaco Memo. Number 1, corporate culture. The Department of Justice will now assess your corporate culture. So that means you as a compliance professional, and once again, it doesn't matter what your role is. It doesn't matter if you're like myself and Isabella, lawyers, whether you're a quantitative numbers person, whether you're in-house, whatever your role might be, you need to start thinking about how do we assess, measure, monitor, and then improve our corporate culture. So that's number 1. Number 2 is the Department of Justice slightly changed the requirements around cooperation. Now, under prior U.S. law, you can get a discount of a fine and penalty all the way to a 0, or what we call a declination. That's 0 fine and penalty. If you have 4 components. Number 1, you self-report. Number 2, you extensively cooperate with the department during the investigation. Number 3, you remediate your compliance program to fix the problem. And number 4, you pay back any ill-gotten gains. Let me focus on 2, cooperation, because the Department of Justice said 2 things in the Monaco Memo. Number 1, they want all information about any potential culpable parties to bribery and corruption. That doesn't mean information which shows guilt. It means all information about all parties, and the Department of Justice will determine what information, if any, they want to use. But number 2 is they want it fast and faster and fastest. So that makes speed important. Now, speed does not mean we are inefficient. What speed means is you have to do your investigation, and well, we'll just pick on Isabel here because she could be the one that's most impacted by this. She gets a call from energy company, says, we've discovered something, could you come talk to us? She comes and talks to them, proposes an investigative protocol, begins her investigation. Typically, she would do her investigation, report to her client, make a decision based upon what she finds, remediate, self-report, or other. However, now the Department of Justice wants speed at every turn. They want speed in terms of your self-reporting, and that is an incredibly difficult decision. has to be made literally at the highest levels of an organization. But also they want speed in terms of your investigation. So they want Isabel to find out as quickly as possible through both interviews and documents what's out there, and they want her to turn that information over to the Department of Justice. Now, as a lawyer, the Department of Justice is not your client. Your client is your client. And you, if something comes in, certainly, even if, you know, if it's negative or shows illegal conduct, you sit down with your client, you talk them through it, you help them understand the implications of it. You're going to turn it over to the government because you've self-reported, but you always have those conversations with your client first. Well, the Department of Justice doesn't want that. They want the documents. So that's a pretty big change. But the point for the in-house compliance professional, now let me speak to you, not outside counsel like Isabel might be, is your investigative process and protocol, you must have it down in writing so that if a tip comes in, a report comes in on your hotline, if internal audit picks up something during a routine audit, you find out one of your competitors had got in trouble for something, whatever the indication might be, is now you need to immediately assess that information, what we would call triage it, and get it to the right person. Is it something that appears to be relatively minor that you can investigate internally? Is it something that appears to be serious that you have to pick up your phone and call Isabel now? Is it something in between? Do your if you do an internal investigation, do the investigation, get it in front of the decision makers in your company and make a decision. But all of that needs to be written down now before the call comes in, before the tip comes in, before you are made aware of it, so that you can quickly and efficiently do this. The clock is ticking. So that's the part on the investigation. Second change, and this really is new. The department said, as part of a best practices compliance program, we've always had the prong of incentives and discipline. Discipline's easier. If somebody does something wrong, what happens to them? Are they fired, or do they not get a promotion? Does a warning letter go in their file? Whatever the discipline may be. And on incentives, we've known for a long time you should have incentives for doing business ethically in compliance. Typically, that's in the form of a year-end discretionary bonus where 5, 10, or 20% of your bonus is based on you doing business ethically in compliance. Now, I understand it may be difficult to figure out how to evaluate that, but that's where HR could be a huge boon to you, because that's what HR does on a routine basis, is evaluate employees. But now the department has said, if someone in your company engages in bribery and corruption and they receive some sort of bonus for that, or payment for that, they want you, the company, to claw that back. So it's called a clawback. Clawbacks, I must admit my ignorance of Brazilian employment law, so I'll have to talk about it in terms of the law I know, which is in the United States. In the United States, an employee's salary it's like the Bible. It is sacrosanct. Once you're paid, you're paid. Whatever your salary is. Now, you can get overtime, you can get a bonus, you can get other discretionary forms of payment. But once you're paid, they can't take it back. Period. No way, no how, no anything. But if I'm an employee and I get paid a salary, whatever they may be, but if I'm paid a bonus based upon my sales, that is eligible for a clawback if the company has the contractual right to do so. So it's an executive's contract may have that written into it, but you have to have the right to clawback written into your contract in the United States. So that's sort of point one. You're going to have to look at your executive compensation contracts to see if you legally have the right to claw back that money. And if you don't, you're going to have to put that in your contracts. Now, it's one thing for you to say, Tom, we want to hire you as our CEO, and here's our contract, and we have clawbacks written into our contracts. I'm probably going to sign that. It's very different if I'm a senior executive at a company and the compliance officer comes down and says, well, this is a new rule, and we want to change your contract. I'm like, oh, you want to make an amendment to my contract? What are you going to give me in return? And it becomes a negotiation. The company says, well, we're going to fire you if you don't sign a new contract on. Well, you can fire me, but you have to have cause to fire me. And if you don't have cause to fire me, you have to pay me out for my entire contract. So that could lead to some difficult discussions, that clawback requirement. And now the Department of Justice says you don't simply have to have the right to clawback, you have to exercise that right. So in the United States, that would be a civil lawsuit. So at what point do you file a civil lawsuit? The way the Monaco Memo is phrased, it may be during your investigation. Well, that has huge implications. If I go off and file a lawsuit and Isabel's trying to get cooperation from witnesses, it may be at cross purposes. Exactly. So it's something that can be done, but it raises lots of questions that we don't have the answers to yet. The third change, and this is a change sort of back to the future. Under the Trump administration, there was a memo called the Benchkowski Memo, and it dealt with monitors. And it basically said, we are very rarely going to have a monitor. And here's the criteria the prosecutor must show to appoint a monitor. That's thrown out. It's no longer valid. The presumption now is you will have a monitor. And in the past, the test for a monitorship was something like, have you implemented a compliance program, an effective compliance program, number one, and number two, have you tested it? Almost every company has implemented a compliance program, but many have not fully tested it before they conclude their enforcement action. Well, now there are 11 factors that the DOJ will consider, one of which is, did you self-disclose? Well, what does that have to do with building out your compliance program? Nothing. But now, whether you self-disclose in a timely manner is a factor as to whether you get a monitor or not. Second new factor is, did you cooperate fast enough? So I gave that whole sort of long recitation about the speed now. Well, that's now a factor as to whether you get a monitor. So things are a little bit different. I would expect more monitors going forward, but we'll have to just wait and see. And then the final point is also something that was raised earlier, and that's CCO certification. What that means is if your company is involved in an enforcement action and enters into a settlement agreement with the Department of Justice, at the end of the probationary period, 2 or 3 years, the CCO must certify personally and in writing that the compliance program is reasonably effective. As I'm sure it has in Brazil, it has caused great consternation here in the United States among chief compliance officers. They're worried about personal liability. They're worried about how would you ever be able to know if your program was reasonably effective everywhere? And what does even that word mean? Once again, we don't know the answers to those questions, but the DOJ has made clear CCO certification is here to stay. So if I got a call from a company that had $1 billion fine and they said, Tom, we've read your book, you're the guy, we want to hire you as our CCO and to get us through this remediation, and you're going to have to certify it at the end, I'm going to say, nope, not interested. I don't want to have to, put myself potentially personally liable. So those are really the changes. There's a few more things in there, but I just want to reiterate it's culture, it's your speed of your investigation and your self-disclosure, it's clawbacks, and it's this change in monitors. Now, if the Department of Justice doesn't make any change in enforcement going forward, all of this may be meaningless. So we're going to have to wait and see. And yesterday at a conference in Washington, D.C., the Department of Justice said they anticipate 2 more FCPA settlements by the end of the year, but we don't know when they may or may not settle. So that's the Monaco Memo. This really is a big deal. And you need whatever your role is in compliance, outside counsel, consultant, data expert, chief compliance officer, compliance professional, whatever your role is, you need to now start having conversations internally about how can you improve your processes, how can you be ready, how can you do the culture assessment and improvement part, looking at your investigative protocols and these clawbacks. Try to figure out how to write those into your executive contracts. And if you have to implement a clawback, how would you do so? Like I said, in the United States, it would be a civil lawsuit, but it might be something different in Brazil. So that's the Monaco Memo. Once again, I know I've said a lot. There's a lot more in the white paper, and I'm happy to take questions now, or if you want to follow up later, happy to do that too.
Thank you so much, Tom. Wow, you know, I have read so much about it, heard so much about it, but this was so clear, crisp, very well explained, and a little scary. The only part that I like about it is the monitorships, because as you know, I love doing monitorships, and with Cynthia helping on the side. But Daniela, would you like to start with the questions? Thank you.
Yes, sure. So first of all, thank you, Tom, for your explanation. As Isabel said, very clear, very easy to understand. I do have a question. I saw this week an article saying that somewhere around 20% of the SEC enforcements this year were related to record-keeping failures, mainly focused on use of third-party message apps. And I saw here on the memo that there is an expectation from the SEC that compliance programs include electronic device policy. I wonder what's their expectation, what should we be doing, you know, to monitor, because it's such a challenge to make sure employees are not using third-party message apps. It's hard to monitor. And so I wonder what the SEC expects so we can improve our programs.
Sure, and that's a very important point. So the fiscal year of the United States government ends September 30. So that means they report numbers from October 1, 2021 to September 30, 2022. And fully 10% of all SEC fines, about $2.5 billion in total, were against banks and financial institutions for allowing employees to use instant messaging and other apps that were not captured by their employer. That's a requirement for those industries. They're regulated industries, we call them that. And that's why the SEC brought these actions. They're civil actions, they're not criminal actions. The DOJ would not bring that type of action. So that's why you see it from the SEC. And thank you for pointing that out, because the Monaco Memo references these messaging apps. And if you get in an enforcement action and your company has allowed employees to use these and you don't capture them, you're going to be in big trouble. And I can't put a dollar figure on it, but it's going to be bad. So what all of this means is you have to figure out a way to either restrict instant messaging, which of course is impossible, and number two, to capture it. And a large part of that is going to come through education and training. You have to train, the senior executives have to be trained on that. But most importantly, the middle managers have to be trained on that because they're the ones that are going to have to communicate to the individual employees. If someone uses, let's pick WhatsApp, since that's the most popular. We use it all the time. You guys use it all the time. Isabella WhatsApped me this morning. And they're routinely used for business communications. And they go away. They disappear. And if you haven't captured those, the DOJ will assume that someone has been talking about engaging in bribery and corruption and deleted the message. So it's up to the company to figure out how to capture those. They are a few software products that are beginning to do this. I get calls from people who say they have a product that does it, and we're not quite there yet. But I think right now it's a matter of education. If you're in a bank or financial institution, you absolutely, positively have to do this. The SEC has said their next target is going to be private equity firms. And so if you're in private equity, get ready. They're coming after you. And these are $200 million fines per financial institution. So is $200 million a lot of money to JP Morgan? Probably not. It's still $200 million. So it's a big fine and penalty. And that's the best I can advise on it right now.
Thank you so much. I do work on a private equity firm, and it is such a concern of ours. There is one question here from Tiago. I'm not sure if he wants to talk. I can read the question, but I think we should have Tiago.
Go ahead. You read the question. Okay.
Okay. All right. Sorry about that. So his question is, the Monaco Memo will definitely increase the amount of information companies will feel obligated to provide to the DOJ. Will the DOJ have the resources to effectively digest and make use of this information, or will it simply flood and overwhelm prosecutors and investigators? Do you have an insight?
Yes. And this, although unrelated to the Monaco Memo, this is a new development that the DOJ has made or engaged in that everyone needs to be aware of. And it's the following. In mid-September, the Department of Justice hired someone named Matt Galvin. Matt Galvin was the chief compliance officer at AB InBev in the United States. AB InBev had about 5 years ago an FCPA enforcement action. And as part of their remediation, he created a data analytics program for the company called BrewRight. And it was designed to pick up potential FCPA violations. The internal program was so successful that they expanded it out to about 20 other areas: antitrust, AML, Gibson Entertainment, export control, etc. Matt became literally America's top data analytics expert as a CCO, not the number side of things, not a coder or that sort of thing, but in implementing that program. Matt was hired by the Department of Justice in mid-September, specifically to set up a data analytics program to answer or to respond to directly to what Tiago has raised. That yes, you can flood them with information, but now they have someone who worked with this information in the world's largest beer company or brewery or brew company. I'm not quite sure what the right term is, but AB InBev obviously is in almost every country on earth. And so he's used to working with big numbers, and he was specifically hired to set that up. So they're going to have the capability to do that. But let me take it a step further, because I think it's more significant than even what Tiago has suggested, that if you flood the DOJ with information from your investigation, what Matt was really hired to do was to set up a program so the DOJ could start to proactively investigate companies based on public information. So let's stick with AB InBev, a public U.S. company. So financial information publicly reported in their 10K. And now the DOJ is going to have a data analytics capability to look at that information, not from an accounting fraud, that's the SEC, but from a bribery and corruption perspective. And it may be that they can uncover bribery and corruption by looking at publicly available filings and financial documents. If so, that's a huge change. And that means you may be sitting in your chair thinking everything's fine, and you get a phone call or you get a letter or you get something from the Department of Justice that said, we found this anomaly, please explain. And we'd like an explanation tomorrow because we figured it out and we figure you should figure it out. So if they can successfully implement the system or something like Matt had at Brew Right at AB InBev, then they can have a very sophisticated, proactive approach to enforcement, and that will really change the dynamics. But it also directly responds to the point Tiago raised, which is, doesn't matter how much information you throw at them, they're now going to have the capability to analyze it quickly and efficiently in a way that they didn't perhaps have before.
Great, very good.
I have a question for Tom on the monitors. So my understanding prior to the Monaco Memo was that monitorships would be the exception and not the rule. And now with the Monaco Memo, there seems to be more of an incentive for monitorships. Why? And I know we like working on monitorships, and but why that change in guidance?
I think a couple of reasons. One is companies getting in trouble more than once or recidivists. And right now we have a very big poster child of that in the form of Ericsson, the Swedish telecom company, who agreed to a $1 billion+ fine, and within a year came back to the DOJ and said, oh, sorry, we missed this entire bribery scheme in Iraq in our original investigation. And although we certified, we had told you everything, looks like we didn't. So the Department of Justice is very upset with recidivists. That's number one. Number two is I don't think the DOJ feels like they're getting adequate information from companies who are self-reporting throughout the period of their DPA or NPA. And so they want oversight from an independent third party. I guess the last thing is, not to completely pick on Isabella, but she and I may be the most senior people on this call who have seen sort of the ebbs and flows of monitorships. So in the middle part of the first decade of this year, we saw lots of monitorships. There were claims of too much expense or overreach. And so the Department of Justice cut back sort of in 2010, 2011. As we moved towards the middle of last decade, we saw an uptick in monitorships, partly because we had some massive, truly international anti-corruption cases, and you name the case: Odebrecht, Petrobras, Airbus, Rolls-Royce, across the globe. Then we saw sort of a swing back the other way under the Trump administration to cut back on monitors. So we've seen this ebb and flow, or I've seen it now for 15 years. And it doesn't really surprise me when there's an uptick or a cutback. It just seems to be that way. And maybe at some point in the future, we'll reach some equilibrium. But right now, it's clearly pointing towards an uptick.
Tom, in fact, don't worry. I love hearing my name from you. But I was going to ask you, there's the story that you have told in the past here in Brazil of some of the classes that you gave that I absolutely adore. And I tell my students all the time about this company that had a monitor that was so, quote unquote, abusive. Can you tell us the story?
Sure.
I love
So I work for this company, and we had a monitor that was so difficult for the company to work with. The company ended up pleading guilty to the FCPA charge that we were under a DPA. It's the only time ever a company pled guilty to a FCPA charge, and it was directly because of the overreach of the monitor. It's a public case, but nobody really ever talks about it because the company doesn't want to talk about it. The monitor's now retired, and the DOJ, that they don't want to talk about it because they don't view it as a positive because of how that happened and what happened. But it can be that bad. There have been others that have been very successful, and companies came out on the other side feeling like they really improved their culture and put in a best practice compliance program and felt like the monitor was an instrumental part of that. And I would point to Volkswagen, who is publicly sort of praised. They had a environmental monitorship and a corruption monitorship, and publicly praised both. So it can work very, very well as well. So that's my monitor story.
Yes, I love that story. You know, it's like you say, you know, I'll pay whatever sanction there is, any penalty, I'll go to jail, but take this monitor away from me, right?
Right.
Right. Tom, I absolutely love monitorships. I have worked as an assistant to a monitor. I have worked many times for the company that was always dealing with the monitor. I was a monitor myself. I was appointed as a monitor by the DOJ and SEC. So I'm all for monitorships. I just have a very specific question here. And it sounds like an easy answer, but I think that everyone here on this call is wondering about it. The clawback will not work here because of our labor laws. They're very paternalistic, very protective of the employees. And if the employee has a bonus, there's no way you can take it back from him or her. So if a company here in Brazil was a subsidiary of a company in the US, that, as you said, not only does the company have the right, but it must exercise the clawback. Do the subsidiaries here in Brazil just ignore this?
So at this point, I would have to guess, and it would be a guess, that the DOJ only wants you to go after senior executives, the truly executive leadership team, or whatever you might call the CEO, the COO, the CFO, CIO, CCO, et cetera. And if typically at that level, you can have some sort of clawback. If it's an employee, I think it's going to be extraordinarily difficult. And the description you gave, Isabel, would be exactly the same for an employee in the state of Texas, whether it's salary or discretionary bonus. They can't have it back. Once you pay it, it's yours. So, but if it's the senior executive level, I think that's what the DOJ is aiming for. And hopefully a company would be able to figure out a way to make that work, even for a subsidiary domiciled in a country like Brazil.
Great, thank you. I know that Daniela has a question, but I just want to remind everyone, the audience, that you can ask your question in the Q&A box, and please identify yourself. Thank you, Daniela. Go ahead.
Sure, no problem. So one question is, how do you see, this working operationally speaking, with regards to the requirement of companies having to produce information to the DOJ before the internal investigation have been completed.
So the question is, how do you do it? Should you do it or other?
I mean, how would operationally work? You know, because if you don't have all the work completed, would we have to provide them with everything we find, like on a day-to-day basis, or I'm a little bit confused on operationally how it will work.
As well, you should be confused because it's a confusing requirement. Now, according to the Department of Justice, they want that information yesterday. So, which means they want it now. And they specifically said, if you come across what we call hot docs or hot documents in the United States, they want to have them now. I really don't know how you can do that because, once again, my client is not the Department of Justice. My client is the company that hired me. And for me to give something to a third party without the company knowing may be a violation of my ethical obligations. So I don't know how that's going to work, but they have said, if you find out information, you pick up the phone and you call us and you email or you fax us. I guess fax still exists, those documents, because we want them and we want them yesterday. And as crazy as that may sound, as confusing as that may sound, that's what they've said.
Yeah, thank you. We do have another question from Joan Elec. So the question is it possible to implement or suggest to the DOJ an assessment of monitors? Abuse posture shouldn't be acceptable. Assessment should be based on objective criteria. Otherwise, monitorships will always be perceived as a necessary evil and not a legitimate support to improve the culture and practices of a company. Do you agree? Do you agree with that statement?
So I certainly agree that you should not have an abusive monitor. So what a company should do to fully protect itself and to understand its obligations under a monitorship is it should enter into a monitor protocol or program. So the monitor should create a protocol and say, we're going to evaluate, basically a work plan. And then you follow that work plan. And if the monitor exceeds that work plan and then refuses to understand they've exceeded the work plan, you can always go to the Department of Justice, but you have to be able to document these were the steps the monitor said they were going to take, 1, 2, 3, 4. However, they've taken steps A, B, C, D, and it's outside their work program. And we don't believe we should be required to either provide the information or comply with the steps. In other words, you have to document everything that you believe shows the monitor is abusive. You can take that to the Department of Justice, and then the Department of Justice will make a decision. Obviously, the monitor is going to take a different position. And if they have documentation to show, here was our work plan, here's how we believe either our work plan authorizes us to do this, or the information we've uncovered in the monitorship has led us to potentially believing there are violations in other areas, the Department of Justice will probably go forward and support the monitor. So the key is to have a work plan in place for both sides. The monitor knows their requirements. The company knows its obligations. If the monitor exceeds or goes outside the work plan, company needs to raise that with the monitor. If that's not successful, then move on. You can always appeal to the Department of Justice, but you can't just call up and say, he's being mean to us, or he's being unfair, or she is being unfair to us. You have to have documentation to show this is what they were supposed to do, and this is how they have exceeded it.
Now, Tom, and just a question on that topic: is there a guidance on how monitors, what the limits of, I mean, I've worked on a couple of monitorships and interacted with several companies that have been monitored. And, you know, there are situations that are a bit abusive or out of context insofar as document requests, what the limits are. I think the company probably feels like they don't have a say or can't say no. Is there like a manual? Like, is there something that that can guide them in understanding their role, right?
The short answer is no.
Okay.
There is no magic book. You have to remember though that the company has pled or has been in a position where it would potentially have to plead guilty, and it's getting out of it by having a monitor. So the presumption is going to be for the monitor. And a company might complain this is too far, too deep, or too much. But the DOJ just thinks, well, that's part of your penalty for getting in trouble in the first place. So they're not going to have a lot of sympathy. There's an organization called the International Association of Corporate Monitors, IAICM.org. And that organization has some general monitor standards, but I'm not sure that they would really get to the level of specificity. Would probably say something like the monitor should not be abusive. So it's a difficult situation. It's unfortunately not meant to be easy or pleasant. And sometimes it's not. But if they truly do go outside their remit, you can, potentially go to the Department of Justice. But as you didn't quite say, but we're trying to get at is how much do you want to piss off the monitor?
Yeah.
And that's not much.
True.
So there is that too.
No,
Delicately put.
Very good.
That's a good
I love
point.
it. We do have time for one more question. If anyone in the audience would like to ask that question, let us know right away. We can also allow you to talk if you want to. We usually do it in a Q&A box, but if you would like to ask the question directly, I can just push a button here and allow you to talk. Anyone?
I have another question for Tom if no one's going to take you up on
Sure,
that.
go ahead. No, I have 1,000. Tom, we have to do it lunch and dinner with you rather than breakfast.
Yes, you need to come to Brazil.
I've heard that.
So Tom, I read an article and it wasn't quite clear to me on the unintended side effects of the Monaco Memo. And it talked a little bit about how companies may be less inclined to self-disclose, how it may impact investment in compliance teams. I mean, what are the unintended consequences that you see since it's not, it's not an elaborate memo in terms of guidance?
Right. So you're absolutely correct. How is this going to play out in the real world? And I think a fair critique is if we self-disclose and we're going to have all of these new requirements, what are we going to get in return for that? How much less can our fine and penalty be? And what I don't see at this point is a quid pro quo, or meaning what additional benefits do you get from these enhanced requirements under the Monaco Memo if you self-disclose. So your point is absolutely well taken. Should we self-disclose? There's no legal requirement for self-disclosure. It is a voluntary act. There's no U.S. law that requires you to self-disclose, and certainly not under the FCPA. However, if you want to try and get a declination or other reduction of your fine and penalty, that's something the DOJ is going to take into account. So your point's well taken. Will it mean less companies self-disclose? We don't know the answer to that. Unfortunately, we'll never know, because if a company doesn't self-disclose, we don't know about it unless an enforcement action has been brought. As to how this impacts overall compliance, I don't see any negative for compliance programs. I see compliance programs being made more important, particularly around corporate culture. And then some of the specifics we've talked about, what I call ephemeral messaging, or the messaging issue, and then the clawbacks are obviously something new as well. But I don't see right now any negative or unintended consequences for compliance programs.
Thank you.
All right, very good. We still have a few more minutes before we go into our raffle. So if anyone wants to ask a question, or else I will ask you a question, Tom. You're talking about self-disclosing. I just wanted to pick it from there. Aren't the lawyers in the United States like screaming on this self-disclosing quote unquote obligation that they would have? What do they do with the attorney-client privilege? Because here in Brazil, the privilege is a duty of the lawyer. It's in the client cannot waive the privilege. So that is out of question for us. But what are they saying in the state?
So, that's a very, very fair point. Lots of gnashing of teeth, lots of conversations, just like the question you gave me and the conversation we have. And right now, there's no good answer for that. And but once again, if I kind of go back 20 years or so, the Department of Justice has pushed lawyers and companies to effectively waive parts of the attorney-client privilege when they say you have to turn over the facts of your investigation. Because if Isabel does an investigation for me, that should be privileged. Now, what the DOJ would say, well, we're not making you do that, Tom. We're giving you an opportunity to potentially have a reduced fine and penalty or a credit for making this limited waiver. But now they're pushing that envelope a little bit further now, and it's going to be interesting to see if there's pushback from the outside law firm / bar community about this requirement for speed. So once again, it's kind of an ebb and flow of the DOJ pushing and testing limits on this. And one other thing that I didn't talk about was, if you turn anything over to the Department of Justice, anything, you have waived the attorney-client privilege for what you've turned over. So say, once again, Tom Fox Energy Company hires Isabel to give us do an investigation. She does. She gives me a report. That report's turned over to the Department of Justice, and CFO is fired for allegedly either approving the bribe or burying their head in the sand. Well, that CFO, if I try to claw back money, can then say, okay, I want your full investigation and I want everything Isabel did. That includes her report, that includes the notes of her interviews, that includes whatever information she gave the company. Anything which supports her report is now arguably waived. So once you give attorney-client privileged information to anyone outside your company, you've waived the privilege for all purposes. So somebody else can get it. So I really didn't focus on that. That's a subject really of another talk, but it could be a huge problem and something we haven't really thought through all of the implications yet.
Excellent. Thank you. We'll have to come back to this topic next time, Tom. Thank you so much. Having said that, we will see Tom again March 1st, hopefully. And I want to give the word to Daniela and Cynthia, but on my part here, Merry Christmas. Have a wonderful, wonderful end of the year, and we hope to see you again many, many, many times next year. Tom, I've been working on getting you here in Brazil, as you know, and we'll definitely get you here next year. The Brazilians love to listen to you, and you will come. Daniela and then Cynthia.
So first of all, I wanted to thank you again, Tom, Isabel. It's been so many years. I've been learning with you, and thank you for your, this mission of you that, to share all your compliance knowledge with us. Thanks, Cynthia, for the invitation again. It was really a pleasure, and I hope you all a wonderful holiday season.
Well, thank you. Thank you for joining us, Daniela. It was a pleasure to have you with us. And Tom, as always, thank you. And I guess I'll see everyone next year.
Absolutely. Thank you all. I want to thank Tatiana from our firm, and also Professor Carlos Abelera, who is our interpreter. Have a wonderful Christmas and Happy New Year. Tom, we'll speak with you soon.
All right. Thanks, guys.
Bye.
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 See you soon.